In this next section of the presentation, we will be looking at some of the common kinds of claims that an employee may bring against an employer under Australian law. And firstly, we'll be looking at unfair dismissal. Firstly, in the case of a normal business, that is not a small business, an employee must have at least 6 months service before he or she can bring an unfair dismissal claim. In the case of a small business, which is a business with 15 employees or less, that period goes out to 12 months before an individual can bring a claim. Casual employees are also generally excluded unless the casual employee is working on a regular and systematic basis, in which case they may potentially be able to bring a claim. High income earners are also excluded from bringing claims under the unfair dismissal laws. It's currently a high income earner as anyone who earns in excess of around $130,000 or more per annum. So essentially, if an individual has been working firstly for less than 6 months, they're unable to bring an unfair dismissal claim. So I would say to you that if you have an employee who is raising some red flags with regards to either performance or conduct in the initial part of their employment, it's certainly much better to do something about that situation in the first 6 months rather than after that. So apart from anything else, if you were to terminate the person's services in the first 6 months, they're excluded from bringing an unfair dismissal claim. They may have potentially other claims, but they won't be able to bring an unfair dismissal claim. So the essential ingredients of an unfair dismissal claim are this. Firstly, the employee obviously needs to have been dismissed. I say obviously, but it's not always that obvious. Sometimes a person will resign, but will then later say that they only resigned because they had no choice other than to do so. It's commonly referred to as constructive dismissal. Most importantly, and what I'll be concentrating on for the purposes of our discussion today, given the limited time that we have, the primary requirement of an unfair dismissal is, again, obviously, that it is unfair. To be unfair, a dismissal must be harsh, unjust, or unreasonable. The very first thing the Fair Work Commission will look at is, was there a valid reason for the dismissal? In looking at that, the courts have found that a valid reason is one which is not capricious, arbitrary, spiteful. Essentially a reason that has a sound basis, something like poor performance or poor conduct, for example, provide a valid reason. Secondly, after being satisfied that there has been a valid reason for a person's dismissal, the Fair Work Commission will look at the process that led up to that dismissal. The Fair Work Act imposes a number of requirements that need to be met before a person is dismissed. If they're not met, it's likely that the dismissal may be found to be unfair. One of those is that the person be notified of the reason for the dismissal before they are dismissed and given an opportunity to respond to that reason. This is often called natural justice. So if a person does succeed with an unfair dismissal claim, what remedies can the Fair Work Commission order? Firstly, the Fair Work Commission can order that the person be reinstated. So essentially overturn the decision to dismiss them, the person comes back to work. The Fair Work Commission can also order that the employer pay the former employee compensation. This can be in conjunction with reinstatement. So a person can be reinstated, brought back to work, and also given compensation. However, the amount of compensation that can be paid is capped at 6 months of a person's salary. They cannot be paid any more than that in compensation in respect of a claim of unfair dismissal. However, in addition to any compensation, there are a number of other costs associated with an unfair dismissal. There's always a lot of time involved in preparing statements for the Fair Work Commission, even in defending an ultimately unsuccessful claim. It's the financial cost perhaps of receiving legal advice or the like. can also be damage to an organisation's reputation, a negative impact on work culture. In summary, a claim for unfair dismissal can provide some very unwanted distractions from the main game of getting on with the work that your High Commission, Embassy or Consulate is involved in. Let's look now at an adverse action claim and what the essential ingredients of such a claim are. Under the Fair Work Act, a person can bring an adverse action claim if some adverse action has been taken in respect of them, and we'll look at what constitutes adverse action shortly, and if that adverse action, i.e. some detrimental action, has been taken because the person exercised or threatened to exercise a workplace right. We'll look at what workplace right means in a moment as well. So firstly, adverse action is defined very broadly in the Fair Work Act. It can be obvious things such as dismissing an employee or demoting them or basically also doing anything to the employee's detriment is how it is expressed in the Fair Work Act. So it obviously covers a potentially wide range of activities. A workplace right is also defined very broadly in the Fair Work Act, and it certainly includes making a complaint or threatening to make a complaint. It includes a range of things, minimum employment conditions guaranteed under the National Employment Standards and the like, workplace right to have any of those things, an entitlement to annual leave, an entitlement even to something like having a pay slip produced. So, in very broad terms, if you do something to an employee's detriment and the employee can show that you did that because, for example, the employee had made a complaint about something else, there's a potential adverse action claim. It is also the case that under the Fair Work Act, it is up to the employer to prove that the reason for the adverse action wasn't the workplace right. So in that example I've just given, it would be up to the employer to show that the dismissal was not because of the complaint of bullying 6 months ago, but was because of the poor performance or conduct, rather than the employee needing to make out his or her claim. It is also the case under the Fair Work Act that the workplace right need only be one of the reasons for the adverse action for the claim to succeed. So those two things, along with the very broad definitions of adverse action and workplace right, means it is, with a little imagination, potentially possible to fit many sets of facts into the definition of an adverse action. If an employee is able to make out an adverse action claim, the Federal Court or the Federal Circuit Court, depending on where the action is brought, can essentially make any order it sees fit. This can include orders for compensation. Orders for compensation are not capped in the way they are in respect of unfair dismissal. Court can order, theoretically, any amount in compensation. Compensation can also be for economic loss or non-economic loss. And by non-economic loss, I mean things like hurt feelings, distress, potentially a very wide scope for orders of compensation. The court can also make an injunctive order. By that I mean an order for an organisation to stop doing something, stop the process of dismissing someone, for example. Court may also order, if the person has been dismissed, that they be reinstated, and also a range of penalties if an organisation is found to have taken an adverse action as defined in the legislation against an employee. So a very broad range of actions that the court can take against an organisation in respect of a successful claim by an employee.